Our final case today is number 22-210, Bevel versus State of Florida.
Thank you, Your Honors. May it please the Court, I'm Barbara Basharis, representing Thomas Bevel. I've asked to reserve 5 minutes of my time. Mr. Bevel is asking this Court today to vacate his sentence of death. I should say his sentences of death. He has 2 death sentences that were imposed for the killings of 2 individuals, and one of them being a 13-year-old boy. The first reason that the first argument I'd like to talk to you about, and I'm going to rely on my brief for a couple of the arguments raised, is that the Court abused its discretion in disregarding uncontroverted expert testimony about Mr. Bevel's extreme mental and emotional distress in the form of ongoing depression and post-traumatic stress disorder. The trial court appears to have disregarded uncontroverted expert evidence for possibly 2 reasons. One, looking at the mitigating circumstances in the sentencing statute. Excuse me. The court appears almost to have collapsed the factors that the capital felony was committed while the defendant was under the influence of extreme mental or emotional disturbance, with the separate factor that the capacity of the defendant to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. These are 2 separate factors, and the factor that was charged and on which the jury was instructed that was argued at trial was B, 7B, that the capital felony was committed while the defendant was under the influence of extreme mental or emotional disturbance. In support of this factor, the defense offered extensive expert testimony that was not rebutted by any state expert, and the bulk of that as to this factor came from testimony of Dr. Gold, who explained that the defendant suffered from post-traumatic stress disorder and depression linked to numerous traumatic and adverse childhood experiences in Mr. Bevel's background. His mother's death, drug use, exposure to domestic violence, exposure to physical and sexual abuse as a child, and substance abuse. The trial court was somewhat dismissive of the expert opinion as being based on self-reporting, because it is true that some of the expert testimony at trial was based on Mr. Bevel's self-reporting of numerous head injuries that he had suffered as a child and a youth. But Dr. Gold's opinion about post-traumatic stress disorder and ongoing depression was corroborated not only by 2 other experts, but by lay witnesses who corroborated the early exposure to drug use, corroborated some of the head injuries that Mr. Bevel suffered, corroborated the violence, corroborated the loss of his parents, his mother in an accident, his father indirectly to heroin abuse. And so his opinion was not just based on self-reporting. It was based on extensive records. It was based on extensive evaluation of Mr. Bevel. And as I said, it was not contradicted in any way by any evidence the state presented. The other expert opinions were provided by Dr. Wow, who testified to extensive testing that he did with Mr. Bevel, corroborating evidence of brain damage, and Dr. Negan, who reviewed scans of Mr. Bevel that again corroborated extensive brain damage and were consistent with the conclusions drawn by Dr. Gold.
And the court found mitigation on that basis, right? In the sentencing order?
The court found they called it non-statutory mitigation of brain damage. Yes,
so it really
gave
raises
little
the
weight.
question of, I mean, it seems like from a harmless error, I mean, I'm not suggesting that I agree that there was error on the emotional disturbance
Yes,
part, but given that the court did take that into consideration and, you know, assigned it the weight that the court thought was appropriate, it seems like it's kind of, it wouldn't have affected the outcome either way.
Your Honor, Mr. Bevel disagrees because the simple finding of brain damage, which was corroborated by or demonstrated by all of the experts, is much narrower than the statutory mitigator that the felony was.
But am I correct in understanding that the experts other than Dr. Gold did not opine concerning the existence of the extreme mental or emotional disturbance?
That's correct.
I mean, so Dr. Gold was all you have, the actual opinion that
In terms
existed.
of the opinion supporting that particular aggravator, that's correct, Justice Kennedy. His opinion was very clear and stated repeatedly that he believed that aggravator was satisfied.
Well, wasn't he also very clear
it.
that he really hadn't examined the defendant here in the context of this crime? He was simply looking at the circumstances that created the PTSD and depression, and not linking that up in any way with the circumstances of this crime, and no explanation of how that could result in what was manifested in this case.
I can agree with that to a point, Justice Kennedy. I believe he
I think
did,
some of it that's kind of clear in the
I believe he did explain how Mr. Bevel's background brought him to a point of committing these crimes of violence. I believe.
But essentially, he was saying
that,
he was saying that because of that, he was always on the verge of doing something like this. He was
exactly, Your Honor. He was always under the influence of extreme mental or emotional disturbance. That was his opinion, that he had untreated post-traumatic stress disorder and depression that he lived with constantly, including at the time of the offense. What he declined to do, and what we're saying the statute does not require, is he declined to draw a direct nexus between the mental and emotional disturbance and the specific crimes committed. Because there is nothing in the plain language of the sentencing statute saying that nexus has to exist. The mitigation, particularly this subsection 7B of being under the influence of extreme mental or emotional disturbance, does not require that the extreme mental or emotional disturbance caused the crime. It requires that it exist and that defendants suffer from it.
If we accept the argument, even in its purest form, that there is uncontroverted evidence of the PTSD and depression, haven't we before held that if there's evidence on the part of the defendant of purposeful conduct like concealment, that the trial court doesn't abuse its discretion when it nonetheless rejects the uncontroverted evidence of the kind you're describing? Isn't that our law?
Your Honor, I believe that the cases that have done that are again, and some of this do it more clearly than others, they're collapsing subsections B and F into the same factor. If you look at subsection F, the capacity of the defendant to appreciate the criminality of his or her conduct or to conform his or her conduct to the requirements of the law.
So you'd ask us to recede from SPAR, for example?
I think that this court has other precedent that's completely consistent with what I'm saying. The Duncan decision is one such decision that I think was mentioned in the briefs, where the evidence of purposeful conduct is what refutes the mitigator that the defendant could not conform his conduct to the requirements of law. If you have that evidence of purposeful concealment, for example, afterwards, that shows that the defendant could, in fact, control his conduct, direct it purposefully. But I think the better precedents, which do exist from this court, are the ones like Duncan that recognize that refutes subsection F, that the subsection B about being under the influence of extreme mental or emotional disturbance is what allows mitigation. For example, when somebody would not be able to prove an insanity defense but is still under the influence of an ongoing condition that affects their behavior, their comportment. So the one may have, subsection F may have more of an implied nexus in the sense that if you are looking at purposeful conduct, as this court has done, you would be looking at it in the context of a specific crime. But there is no nexus requirement in subsection B. And Dr. Gold was very clear when pressed on this several times.
What does the word influence, what work does that do? It is under the influence.
Mm-hmm. When the defendant was under the influence of extreme mental or emotional disturbance,
I mean,
that condition was present and was affecting him. And that's exactly what Dr. Gold said. He said it was true before and during the commission of the crimes. Mr. Bevel suffered from conditions that were ongoing. It's like having, I don't know, untreated diabetes. You don't stop having it for 2 hours and then have it again. It's an ongoing condition. So Mr. Bevel's condition was also ongoing, and clear testimony from the expert that he was under the influence of those conditions at the time the crimes were committed was disregarded by the court. And that's why, Justice Muniz, going back to your question, the fact that the trial court did acknowledge the also uncontroverted evidence of brain damage does not cure the error in disregarding uncontroverted expert testimony about the emotional disturbance, mental or emotional disturbance mitigator. You have no further questions on that mitigator. I was going to move on to the second part of the argument, which is the jury instruction, a requested jury instruction. Thank you, Your Honors. The jury instruction argument is, I think, very straightforward. This court has rejected similar arguments in the past. We believe that the court should reconsider that rejection in the context of the way the different parts of the current jury instructions work together. Mr. Bevel requested an instruction that encompassed some language that is in the standard instructions. He would have instructed the jury, you must consider whether the aggravating factor or factors sufficiently outweigh the mitigating factors you have found. That's consistent with the standard instructions. Regardless of your findings as to aggravating and mitigating circumstances, you are neither compelled nor required to recommend a sentence of death. That's verbatim in the standard instructions. He would have simply added, before that, you have complete control and discretion in determining whether the circumstances of this case justify a sentence of death. And then after that sentence, you may always consider mercy in making this determination.
I don't see how that really adds much to the standard instruction. I mean, I understand you may want to do it and you want to kind of drive it home, but I'm struggling to see how that really adds, because that last sentence in the standard instruction, I mean, the inescapable inference from that is you can show mercy. I mean, you don't have to impose it, even though these factors would weigh up and say, well, it ought to be imposed. So I'm just,
and Your Honor,
again, I understand why you would want it, but I just don't really understand that you get any materially significant additional, anything materially different that's additional than what the standard instruction gives you.
And Your Honor, if that were the last thing the jury were told, I would have a harder time responding to your question, but it's not the last thing the jury is told, because after the jury hears that and the court goes through all of the other instructions on weighing and balancing that has to take place, the jury gets general instructions that says you must follow these rules in order to make a lawful decision. You must follow the law as it is set out in these instructions. Your decisions must be based only upon the evidence that you have heard from the testimony of the witnesses, have seen in the form of the exhibits and evidence and these instructions. Your decisions must not be based upon the fact that you feel sorry for anyone or are angry at anyone, a line about don't hate the lawyers, and then a final instruction, your decisions should not be influenced by feeling of prejudice or racial or ethnic bias. And again, your decisions must be based on the evidence and the law contained in these instructions.
I guess, so my question here is, this is all reviewed for abuse of discretion, right? Mm-hmm. Okay. Let's say the judge adopted your proposed jury instruction in part. Mm-hmm. Help me identify what part of what you're arguing for was an abuse of discretion. Did the judge have to adopt your jury instruction word for word as proposed? Because it seems to me like perhaps you could make an argument that the ordering of the provisions would make things clearer, more favorable, less favorable. But we give trial courts discretion about this. Mm-hmm. Help me understand what you're saying is abusive about what the court mm-hmm. did here, because I'm not seeing mm-hmm. that.
Thank you, Your Honor. The abuse of discretion is that in the context of the final instructions I just read, that line about you're never compelled or required to impose a sentence of death really does not convey that a juror individually can bring mercy into the equation. We talk about it.
Help me understand mm-hmm. that. How is it that a trial court abuses its discretion when it says to the jury, you're not compelled to do something? How is that an abuse of the trial court's discretion?
To say that by itself, I don't think is an abuse of discretion, but then to go on and limit with those general rules saying that you have to follow the law and only the law that's given to you here.
That sounds like an abuse of discretion. You have to follow the law?
No, but when that leaves no room for a consideration of mercy, when you're telling the jury at the end, you can only decide based on what you heard basically in the four corners of the courtroom. You cannot bring your own sense of extending mercy into this decision.
Don't we ask juries all the time to limit their consideration in a case to the evidence presented? I mean, how is that an abuse of
absolutely?
discretion?
But what's different here, Your Honor, is that this is a life or death decision, and that we recognize.
You're saying that if contrary to fact here, the judge had said you're free to consider things outside the four corners of this courtroom, including, what you think about, the state of American society, that somehow would be less abusive of discretion?
No, Your Honor, that I would not argue that to you. What I would argue is that the requested jury instruction that you may always consider mercy in making this determination was appropriate, was legally correct, and would have served as a counterbalance to the rest of the limiting instructions, especially the line, your decisions must not be based upon the fact that you feel sorry for anyone or are angry at anyone. Because if you just have a juror who has heard the type of mitigation that is presented in many of these cases, you see them as I do. Mr. Bevel's case had extensive mitigation. Mr. Bevel had a childhood that none of you would wish on anyone. And to tell the juror at the end of the mitigation case, basically, when they're retiring to deliberate, you can't base your decision on feeling sorry for anyone, removes that element of being able to extend mercy based on the defendant's circumstance. And so yes, I'm not arguing, Justice Curiel, and I don't want to overstate that the jury should be able to consider anything or bring in their views of what's going on outside the courtroom. That would be almost a form of jury nullification. What I'm arguing is that these standard instructions, especially with that final line in it, do not adequately tell the jury what it can consider in reaching its decision. Our law says that the jury can always extend mercy. This court, the U.S. Supreme Court, has repeatedly recognized that a jury can always extend mercy, but that single line that you're not required to impose a death sentence, when it's followed by you can't make a decision based on feeling sorry for anyone, does not adequately tell the jury that it can extend mercy.
Isn't the whole scheme of mitigation really about mercy? That we're going to take all these things into account that really are not not necessarily directly related to the circumstances of the crime and what, by some objective standard, might fit that crime. We're going to take into account what fits this defendant and where the defendant has come from and all those circumstances. And it seems like to me that that's a sort of that could be conceptualized as showing mercy based on the mitigating factors.
It could be conceptualized as showing mercy, but if you don't tell the jury that's what they can do, you can't assume.
But you're telling them they can take all that into account.
That they can take it into account in balancing it against the aggravation. Right. Yeah, they absolutely are told they can take it into account.
And then they're told that even once they take that into account, they still don't have to impose. There's nothing about that that requires them to impose a death sentence.
They're not required to vote to kill somebody, but they can't base their decisions on feeling sorry for someone. So what does that do? That leaves a conundrum. If you feel sorry for the defendant, and if you think that might be a reason to spare the defendant's life, you've just been told you can't base your decision on that. So yes, I'm not required to sentence this individual to death, but I've just been told that my reason for not doing so is unacceptable. So that's where the law leaves me.
Thanks. You can have 2 minutes for rebuttal.
Thank you, Your Honor.
Good morning. May it please the court, counsel. My name is Doris Meacham, and I'm here on behalf of the state of Florida. To address the first claim regarding the extreme mental or emotional distress claim, there was competent, substantial evidence for the trial court to find that Mr. Bevel was not under the influence of any mental or emotional disturbance at the time. He took into consideration the testimony of all three experts, in particular Dr. Gold. And what he found was that none of the experts had ever spoken to Mr. Bevel about the circumstances of the crime. None of them knew what happened. None of them knew what was going on through Mr. Bevel's head at the time of the crime. And based on this court's precedent, that is necessary. Dr. Gold was the only one whose opinion was that Mr. Bevel was under the extreme mental disturbance of PTSD. But he made it very clear that he based it on the fact that he suffers from PTSD or is diagnosed with PTSD, and that doesn't go away. But he was very clear that he was not making a connection between the PTSD and the reason for Mr. Bevel committing the crimes. And as Justice Kennedy stated, what is under the influence? Just because he suffers from or is diagnosed with PTSD does not mean he was triggered or under the influence of the PTSD that evening. In fact, as the trial court stated, everything points to the opposite of that. No one can testify that there was any commotion, any argument, anything to trigger Mr. Bevel that night. In fact, Mr. Bevel, from the testimony, got up at 3 o'clock in the morning, knocked on Mr. Stringfield's door, surprised him, and shot him in the head, point blank, killing him. There was no provocation. There was no argument. He then proceeded to shoot at Miss Smith, who was in the room with him, over 13 times, no provocation, and left her what he thought to be dead. He then went out into the living room where Mr. Stringfield's 13-year-old son was sitting on the couch with a remote control in his hand and shot him twice, once in the head. No provocation, nothing that would trigger PTSD. The judge also took into consideration Mr. Bevel's actions after the murder. He proceeded to ask Ms. Dumas, who was also in the home, to leave with him. Reason he did not kill her was because she was pregnant with his child. Before he left, he secured the front of the door with a burglar bar, which made it difficult for anyone to enter the home. He had the thought to leave with Ms. Dumas because in the back of his head he knew that he could convince her to be his alibi and to change her story to comport with his. He was able to evade the police for over a month. And when he was finally caught, he had multiple stories about what happened that evening. From I didn't hear anything, from 2 other people did it, to Mr. Stringfield was going to kill me, and I was in fear. None of that was substantiated through the testimony of the surviving victim, Ms. Smith, or by Ms. Dumas. In fact, it all corroborated the fact that this was an unprovoked murder on both victims. The court also took in...
I'm thinking about this. Under the defense's theory about this PTSD, if the defendant here had put out a contract hit on someone, just because he had a score to settle over some debt or something like that, under Dr. Gold's theory, that would be under the influence of which just
right. The fact that he walks around
because he's got it all the time,
PTSD.
and what it's like anything he does is because of that.
Right.
It seems to prove a whole lot too much.
Right. I would compare it to someone who has cancer every day and has a heart attack and dies. The cancer didn't cause the death. The heart attack did. The fact that he's walking around with PTSD does not explain what he did that evening without actually having spoken to him and gotten some information. And as he said, I mean, Dr. Gold specified that the reason he was testifying was to gather mitigation for the defense, which he did, because everything he testified to regarding his upbringing, the sexual abuse, the growing in a neighborhood full of violence, being shot at, all of that mitigation that Dr. Gold found was also found by the trial court as non-statutory mitigation. So all of that was actually considered by the court and given very little to no weight. So I don't believe that Mr. Bevel has proven that he was under the influence of any extreme mental or emotional disturbance at the time of the murders. Are there any more questions on that claim? I will answer as to the next claim, which is the mercy rule, which by all counts, 7.11 is considered by this court as the mercy rule. The instruction proposed by Bevel was not required to ensure the consideration of mitigating factors, and the failure to give special instructions does not constitute error where the instructions adequately address the applicable legal standards, which this jury instruction did. And additionally, defense counsel was able to argue mercy. As he stated in his argument, it is a godlike decision, and I urge you that if you go back to that deliberation room and you're sitting on the fence as to what truly would be appropriate in this case for Thomas Bevel on this day, I urge you to err on the side of mercy. And the law, of course, contemplates mercy, because the law repeatedly tells you, and His Honor will actually utter the words, as he did in jury selection, and before we even started this trial, the law neither requires nor compels. This was an accurate instruction, and there was no abuse of discretion. If there are no further questions, the state would respectfully ask that you affirm Mr. Bevel's death sentences. Thank you.
Thank you, Your Honors. Yes, the experts did not talk to Mr. Bevel about his state of mind at the time of the murders or the details of the murders, but Dr. Gold testified unequivocally that Mr. Bevel was suffering from post-traumatic stress disorder. There's the idea of being triggered, that somehow post-traumatic stress disorder doesn't affect you and then you blow up and do something and then you go back to normal, is something that might come from, a police show or a TV show, but it's not how post-traumatic stress disorder works. And Dr. Gold explained that in his testimony. This condition was ongoing and was influencing Mr. Bevel, both at the time of the killings and before and after. So if anything, if you were looking at whether there was something to trigger him, that might be getting you into the realm of subsection F, where somebody became unable to control himself or conform his conduct to the requirements of law. But we're talking about subsection B, which does not have the same requirement. Justice Kennedy, your question about putting out a contract is interesting. What I would just take issue with is saying anything he does is because of his PTSD. No, that's not what we're saying, and that's not what Dr. Gold was saying. But I think it is conceivable.
Well, he's saying it's influenced by it. I mean, if he finds that if he finds that the aggravator exists, he is saying it is influenced, right? It was influencing him.
But not necessarily causation.
Well, then how is it mitigation then? I mean, there has to be some connection, or otherwise none of it. I mean, we have to understand what the legislature is getting at in the context of what the point of the whole listing of the
what the legislature
factors
is getting at with the list of mitigating factors, that there are various circumstances that may make somebody less culpable than another individual. There are various factors that may justify
and the only thing that would possibly
them.
make it relevant to culpability is if it actually affected what happened.
I disagree, Your Honor. I think then you're imposing a nexus requirement that does not exist and has been rejected.
Okay.
Thank you.
Thank you. We are adjourned for today. Thank you.